Dear participants, today our topic is electronic evidence presentation based practices. So first we shall see the importance of electronic evidence, particularly under the new laws that have been implemented from particularly from 1st July 2024, and then we shall see why this subject is very, very important, because electronic evidence is a type of forensic evidence, and we shall see how it is going to be useful. So first we see the use of technology and digital means in processing evidence in Bhartiya Sakshya Adhiniyam 2023 that has repealed the Indian Evidence Act 1872. So the definition of documents has been expanded to include electronic or digital records on emails, server logs, documents on computers, laptop or smartphone, messages, websites, locational evidence, and voicemail messages stored on digital devices. The definition of evidence is another modification. It has also been expanded to include any information given electronically which will enable the appearance of witnesses, accused, experts, and victims through electronic means. It is defined as audio-visual electronic means under Bharatiya Nagarik Suraksha Sanhita 2023 that has replaced the CRPC 1973. So earlier, as we know, the changes were made by the Information Technology Act 2000, in which the 4 acts were changed. That is the Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, by which the cash book, ledgers, etc. in electronic form were made admissible, by which the digital transactions and the e-commerce revolution started in a great way. And then the fourth was Reserve Bank of India Act 1934, by which the RBI came into existence on 1st April 1935. So these 4 acts were amended by the IT Act through section 91, 92, 93, 94 and 4 schedules to the IT Act. Now we see what are the recent changes that have been done on 1st July 2023. 1st July 2024, that is when this act was passed in 2023 December. So it has been implemented since 1st July 2024. And let us see how the definitions of primary evidence and secondary evidence have changed. So definition of primary evidence has been expanded to include electronic or digital record, which is created or stored, electronic or digital record produced from proper custody, video recording simultaneously stored in electronic form and transmitted or broadcast to another, and electronic or digital record stored in multiple storage spaces in a computer resource. That means all the records on computers or say laptops, tablets or mobile phones, these are now admissible evidence and they can be considered as primary evidence. Even the definition of secondary evidence has been changed. So the scope of secondary evidence has been expanded to include copies made from original by mechanical processes, copies made from or compared with the original, counterparts of documents as against the parties who did not execute them, and oral accounts of the contents of the document given by some person who has himself seen it. Now the problem is on electronic devices, everything is in bits, that is binary digits 0 and 1, and how we can determine what is original and which is copied. So the definition has become quite difficult, but I will explain it so that we shall understand the difference between primary evidence and secondary evidence. As you know, in case of manual records, there are certified copies that we obtain from our courts. So there is original and that is in their files, and what we obtain is a certified copy who has been certified by the authorized signatory of the court, like say maybe assistant registrar judicial or someone who is authorized to certify them. Even all the copies uploaded on computer are valid, as well as now e-certified copies are also available, and those who are registered advocates can obtain or download them from internet, maybe after paying the fees. So e-certified copies are also valid. We shall see about the validity of this in the IT Act, chapter section 6 to 10A. Now it will also include oral admission when documents of the document itself is in question. Now genuineness of the documents is in question. So for that there is examiner of electronic documents under the IT Act. We shall see that about that also. So oral admission is needed when genuineness is in question. Further, secondary evidence may be given when the existence, condition or content of the original is admitted in writing. So secondary evidence may also be there along with the primary evidence. So this is the latest change in the definition. Now we see the admissibility of electronic digital record in BSA 2023. So a new section 61 has been added in BSA 2023 to provide for permissibility of electronic or digital record. This is a new change. So apart from the amendments that were done earlier in 2000 by Information Technology Act, this new definition has been added. The language is negative. That means it doesn't say that all electronic evidence is admissible, but it says that no evidence shall be, say, inadmissible on the ground that it is electronic. So it's a negative type of definition, that is, on the ground that it is electronic, it cannot be denied. It cannot be held inadmissible. This is a new, and that changes a lot of contradictory case law, that earlier some high courts held that it is admissible, some high courts said it is not inadmissible. So all those older case law before 1st July has become irrelevant because of this new section 61. Now we see the electronic record, that is provisions relating to certificate in BSA. So a certificate has been added in the schedule. Now there is a new schedule. Our previous schedule was repealed in 1938. So BSA has a new schedule, and that has got two certificates in two parts. So certificate has been added in schedule to authenticate and verify the contents of electronic records with riders, that the conditions that computer must be regularly in use for regular activities by person having lawful control over it, data was regularly fed in it, and computer was in working property, etc. So this certificate is in two parts. Earlier you might be aware that there was section 65B of Indian Evidence Act. Now there is section 63 of BSA. So we shall see what and many words has been changed in this new section 63. So we shall read it verbatim. A proposal has been made to recognize matching of hash value of original record as proof of evidence to ensure the integrity of specific file and not the entire storage medium. See, hash value is something that is technically generated. It has to be generated by whosoever creates the document. For example, police nowadays are creating this evidence, or maybe they might be recording by their own mobile. They might be creating it from computer. Any file has a hash value. This hash value has to be generated. We can't say that it cannot be tempered. What we are saying is that if there is tempering, it can be readily detected. That means if hash value has changed, that means there is tempering or manipulation. And if hash value is not changed, so then we can say that the evidence is integrity is maintained. Integrity means there is no addition, deletion, or modification of the data, that we call as integrity in computer security. Now we see the deleted sections from Indian Evidence Act 1872. So see, these are the sections that have been deleted. The only thing that are relevant as far as this electronic evidence is section 22A, when oral admission as to contents of electronic records are relevant. So that has been omitted because now there is completely new say provision made for it. Then 88, presumption as to telegraphic messages. Telegraph services were stopped by Department of Post in 2013, and therefore now it had become obsolete, and therefore it has been repealed. The previous schedule was already repealed in 1938. Now a new schedule has been added, and that contains certificate in part 2 that is required under section 63, which corresponds to say older section 65 of the Indian Evidence Act 1872. Now the new sections. If we see the new sections in BSA, section 61 is about admissibility of electronic or digital record, and section 170 is of course repeal and saving, that repeals the previous IEA 1872, and the new schedule that has been added. Now we see the definition. So definition of document in BSA, section 21D. So document means any matter expressed or designed or otherwise recorded upon any substance by means of letters, figures, or marks, or any other means, or by more than one of those means intended to be used, or which may be used for the purpose of recording that matter, and includes electronic and digital records. Illustrations, writing is a document. Words printed, lithographed, or photographed are documents. A map or plan is a document. In Hindi we call it exhibit or pradarsh. An inscription or a metal plate or stone is a document. Then a caricature is a document. What is important for us is this 6th clause, that is an electronic record on emails, server logs, documents on computers, laptop or smartphone, messages, websites, locational evidence, that is maybe say now we have GPS system. So locational evidence is also important, GPS tracking, and voicemail messages stored on digital devices are documents. So firstly, there is change in the definition of documents. Secondly, we see section 21E. Another definition that has been changed is I have also written written the name of the act on the top so that nobody is confused whether we are referring to older acts or new acts, and because I am covering three different acts in this presentation. Evidence means and includes all statements, including statements given electronically which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. And all documents including electronic or digital records produced for the inspection of the court, and such documents are called documentary evidence. So here oral evidence and documentary evidence are say included, and we have seen that already record includes the electronic records also. Now we see section 39. This is very important because earlier we had section 45 of say expert evidence. Now opinions of third persons when relevant. Now since digital forensics is also a part of digital forensic, computer forensic, mobile forensic, all these are part of forensic science, and this evidence technically is called expert evidence. So we shall see that this expert evidence is taken now under BSA 39, which corresponds to IEA 45. So when the court has to form an opinion upon a point of foreign law or of science or art or any other field, or has to identify of handwriting, identity of handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, science or art or any other field, or in questions as to identity of handwriting or finger impressions are relevant facts, and such persons are called experts. The illustrations are, the question is whether the death of was caused by poison. Here the forensic expert example is given. The opinions of experts as to the symptoms produced by the poison by which A is supposed to have died are relevant. The question is whether A at the time of doing a certain act was by reason of unsoundness of mind incapable of knowing the nature of the act, or that he was doing what was either wrong or contrary to law. The questions of experts upon the question whether the symptoms exhibited by A commonly show unsoundness of mind, and whether such unsoundness of mind usually renders person incapable of knowing the nature of the acts which they do, or by knowing that what they do is either wrong or contrary to law, are relevant. In this case, in particular illustration, expert will be a psychologist. Similarly, computer engineer or electronics engineer may be an expert as far as electronic evidence is concerned, or any person, or even policeman, because more than 5,65,000 people have been trained in last 6 months. That is, after this notification of coming into effect was published in February till June. So many polices, advocates and judges in judicial academies have been trained. So we shall see now. The question is whether a certain document was written by A, another document is produced which is proved or admitted to have been written by A. The opinions of experts on the question whether the two documents were written by the same person or by different persons are relevant. See, earlier there was GEQD, that is Government Examiner of Question Documents. Similarly, we shall see that under IT Act there is Examiner of electronic documents. So that is also a government organization established say in 2008 under the IT by the Information Technology Amendment Act 2008, which came into effect in 2009. So we shall see that provision also. So in case of doubt, the examination of electronic evidence can also be done by the government examiner. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in a computer resource or any other electronic or other form, the opinion of the examiner of electronic evidence. See, this examiner of electronic evidence is a special organization formed under section 79A, referred to in section 79A of the Information Technology Act 2000, is a relevant fact. So by this subsection 2, it would be clear that this is a new addition, and this has been made admissible. For the provisions of this subsection, an examiner of electronic evidence shall be an expert. So this is the expert evidence. Then we see primary evidence. So primary evidence means the document itself produced for the inspection of the court under new section 57. Explanation 1, when a document is executed on several parts, each part is primary evidence of the document. For example, there is a form that we fill, and there is a counterfoil in the, say, for example, bank forms. So every part is primary evidence. Say postal order, so there is a counterfoil, so that is executed in several parts. Where a document is executed or counterpart, each counterpart being executed by one or more of the parties only, each counterpart is primary evidence as against the parties executing it. So where there are different parts, like say challan is presented in 3 copies and they are made for different persons. So for different parties, it is a primary evidence. Then where a number of documents are all made by one uniform process, as in the case of printing, lithography or photography, each is primary evidence of the contents of the rest. But where they are all copies of a common original, they are not primary evidence of the contents of the original. So This is a third explanation. Then we see further explanation where an electronic or digital record is created or stored, and such storage occurs simultaneously or sequentially in multiple files. Each such file is primary evidence because the hash value generally is the say for such file. Now hash value of medium will not be considered. Hash value of such file will be considered, and therefore each such file is primary evidence. We shall see about that when we see the certificate in detail. Then explanation 5. So where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed. Now see, there is a chain of custody. I will explain that in detail. So chain of custody has to be examined, say produced before the court. That means from acquisition or collection of evidence or recording of evidence until the presentation, because there might be many policemen and public prosecutors that might have been transferred. So that custody is simply the list of persons who have kept that evidence from the say capturing stage up to the presentation stage. That we shall see. I will explain all the stages one by one. Now where a video recording is simultaneously stored in electronic form and transmitted or broadcast or registered transferred in another form of the stored recordings is primary evidence. So whenever there is video recording and simultaneously say storage is done, then such transmission or broadcast or say transfer to another, each of the stored recordings is considered as primary evidence. Seventh explanation is where an electronic or digital record is stored in multiple storage spaces in a computer resource. Each such automated storage, including temporary files, is primary evidence. Temporary files are also there, which are sometimes automatically deleted, but temporary files are proof that it was opened, so they contain some temporary information. Illustration is a person is shown to have been in possession of a number of placards, all printed at one time from one original. Any one of the placards is primary evidence of the contents of any other, but no one of them is primary evidence of the contents of the original. Now we see another addition is section 61. As I told, it is negatively worded, but it will be very clear, and it will say replace a lot of case laws of contradictory judgments of different high courts. So nothing in the Adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record, and such record shall have the same legal effect, validity, and enforceability as paper records. That means it can be denied because it is not properly certified, or because it had been manipulated or tampered with, or because that it is irrelevant, etc., or inadmissible on that record. But it can't be denied on the record on the ground that it is electronic, therefore it is rejected. So on this ground, it can't be denied. Next, we see admissibility of electronic records. This is section 63, new section. It actually some words have been changed. It is same as 65B, but many new words have been changed, and therefore we shall see how it differs from our earlier section 65B. So there have been some improvements, as we can see. Notwithstanding anything contained in this Adhiniyam, any information contained in an electronic record which is printed on paper, stored, recorded, or copied in optical or magnetic media or semiconductor memory, because see, these three are the storage technologies which we call as storage, permanent storage. Optical is CD, DVD, Blu-ray disc. Magnetic is hard disk. Semiconductor is pen drive, flash drive, mobile phone. These are all semiconductor memory. Three technologies are there, which is produced by a computer or any communication device, or otherwise stored or recorded or copied in any electronic form. Hereinafter referred to as the computer output, shall be deemed to be also a document if the conditions mentioned in the section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings with a proper proof or production of the original as evidence, or any contents of the original, or any fact stored therein, stated therein, of which direct evidence would be admissible. So like direct evidence, all these are admissible. This is corresponding to section 65B of the IEA 1872. Now it is called as BSS 63. The conditions referred to in subsection 1 in respect to a computer output shall be the following, namely, the computer output containing the information was produced by the computer or communication device during the period over which the computer or communication device was used regularly to create, store, or process information for the purposes of any activity regularly carried on over that period by the person having lawful control over the use of the computer or communication device. Of course, this definition of computer and telecommunication device is given in IT Act, and those are valid in this Act also, as well as in BNSS. During the said period, information of the kind contained in the electronic record of the kind from which the information content is derived was regularly fed into the computer or communication device in the ordinary course or the said activities. Then throughout the material part of the said period, the computer or communication device was operating properly. See, these are the new additions, as you might notice. Those who are familiar with 65B of the older act, was operating properly, or if not, then in respect of any period in which it was not operating properly, or was out of operation during that part of the period, was not such as to affect the electronic record or the accuracy of its content. And this is as per the recommendation of the parliamentary committee headed by Brijlal, the former DGP. So those suggestions given by parliamentary committee are around 1200 pages, and that recommendation has been accepted here, and therefore this new clause C. The information contained in the electronic record reproduced or is derived from that information fed into the computer or communication device in the ordinary course of the said activities. This is to ensure that it is not tempered. Then there is subsection 3. So where over any period the function of creating, storing or processing information for the purposes of any activity regularly carried on over that period, as mentioned in clause A of subsection 2, was regularly performed by means of one or more computers or communication device, whether in standalone mode or as a computer system, or on a computer network, or on a computer resource enabling information creation or providing information processing and storage, or through an intermediary. Intermediary means say WhatsApp, Google, Facebook. These are called intermediaries as per the IT Act. All the computers or communication devices used for that purpose during that period shall be treated for the purposes of this section as constituting a single computer or communication device, and resources in this this section to a computer or communication device shall be construed accordingly. Construe means in Marathi, Hindi we call it arthaghatan karna. To construct the meaning of something as per the construction of statutes. In any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things shall be submitted along with the electronic record at each instance where it is being submitted for admission. So this certificate is given in the schedule of this BSA. Namely, identifying the electronic record containing the statement and describing the manner in which it was produced. There are actually two certificates, Part A, Part B. So Part A is by the party which is submitted, Part B is by the expert. Giving such particulars of any device involved in the production or that electronic record as may be appropriate for the purposes of showing that the electronic record was produced on a computer or a communication device referred to in clause A to E of subsection 3, and dealing with any of the matters to which the conditions mentioned in section 3 relate. Then we see further, and purporting to be signed by a person in charge of the computer or communication device. Now there are two types of signatures. We shall see that in IT Act, that is digital signature and electronic signature, both are valid. Or the management of the relevant activities, whichever is appropriate, and an expert shall be evidence of any matter stated in the certificate, and for the purposes of this subsection it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it in the certificate specified in the schedule, and therefore a new schedule has been added. Now for the purposes of this section, information shall be taken to be supplied to a computer or communication device if it is supplied thereto in any appropriate form, and whether it is so supplied directly or with or without human intervention by means of any appropriate equipment. That means recording or other types of equipment without human intervention. It could be automated method also. Like in video conferencing, we get an alert that this call is being recorded or is being live streamed. So these automated methods are included. A computer output shall be taken to have been produced by a computer or communication device, whether it was produced by directly or with or without human intervention by means of any appropriate equipment. That includes printer also, computer printout also, or by other electronic means as referred to in clauses A to E of subsection 3. Now let us see what is this certificate at the end. So certificate under section 63(4)(c). This is corresponding actually to that section 65(b) of the Indian Evidence Act. So part A is to be filled by the party and part B is to be filled by the expert. This certificate looks like I, name, son, daughter. This is part A, to be filled by the party. Son, daughter, spouse of someone residing, employed at this place, do hereby solemnly affirm and sincerely state and submit as follows. I have procured electronic record or output of the digital record taken from the following device: digital record source, tick mark, computer, storage media, DVR, mobile, flash drive, CD, DVD, server, cloud, other has to be specified, make and model, color, serial number of the device. Then IMEI, that is International Mobile Equipment Identification in case of mobile number, UIN, UID, MAC in case of say that is media access control layer of this computer, cloud ID as applicable, and any other relevant information, if any, about the device or digital record, and that is to be specified. Now, the declaration is the digital device or the digital record source was under the lawful control for regularly creating, storing, or processing information for the purposes of carrying out regular activities, and during this period, the computer or the communication device was working properly, and the relevant information was regularly fed into the computer during the ordinary course of business. This is as per same language as given in section 63(4)(c). If the computer digital device at any point of time was not working properly or out of operation, then it has not affected the electronic or digital recording of its accuracy. The digital device of the source of the digital record is owned, maintained, managed, operated by me. Select as applicable. Now the second part is to be filled by the say party. This is in continuation of part A. Then the certification part is there. I state that the hash values of the electronic digital records is, this hash value has to be mentioned there, obtained through the following algorithm. Either it is secure hash algorithm 1, SHA-256, MD5. See, there are 4 lakh computer engineers being passed every year in India, and all the computer engineers know about this hash value algorithms. So there are many electronic experts also, and this is a compulsory subject, cryptography and network security. So all computer engineers know about this algorithm. So it is a reliable technique. Other is legally acceptable standard. These have been specified in Schedule A of the IT Act. Hash report to be enclosed with the certificate. Now, if there is any tampering or manipulation, it can be detected from the hash value. That's why it is important. So name and signature, date, time, and hours in 24 hours format, and place. This is the part A certificate. Now part B, similar. This is to be filled by the expert, that is forensic expert or digital forensic or cyber forensic, computer forensic expert. For example, so name, son, daughter, spouse of this, residing, employed at this place, do hereby solemnly affirm and sincerely state and submit as follows. The produced electronic record output of the original record are content from the following device: digital record source, tick mark, computer, storage media, DVR, mobile, flash drive, CD, DVD, server, cloud, other is to be specified, make and model, color, serial number, IMEI, UIN, UID, MAC, cloud ID as applicable, and any other relevant information, if any, about the device or digital record, that is to be specified. Then there is again part of this certificate. I state that the hash values of the electronic digital record is so and so, obtained through the following algorithm: SHA-1, SHA-256, MD5, message digest 5, other, that is legal. This is to ensure that there is no tampering over the network or through any electronic process. So that's why this examine the integrity of the data, that is there is no addition, manipulation, or deletion of the data. That has to be verified. So other legally acceptable standard, hash report to be enclosed with the certificate, name, destination and signature, date, time, hours, and then place. Now we see, coming to the chain of custody. Now this might raise a lot of questions in your mind. How we can determine whether a document has been manipulated, or whether it is say because it is in custody of policeman, it may be in custody of say prosecution, that is police advocate. So what these people have been doing, there could be a transfer of people. So chain of custody is a critical concept in cyber forensics, ensuring the integrity and reliability of digital evidence from the moment it is collected until it is presented in a legal proceeding. So here is discussion on the importance of chain of custody in cyber forensics. First is preservation. So it ensures evidence integrity, that is preservation of original state. So chain of custody ensures that digital evidence is preserved in its original state without any alteration or tampering. This is crucial for maintaining the credibility of the evidence. Now, whether you are a prosecution lawyer or whether you are a defense advocate, so it will be necessary for you while examining the witness or the expert witness. Second is documentation of handling. Every individual who handles the evidence must document their actions. So the documentation must be there at every stage. This helps in tracking any changes and ensuring that the evidence remains authentic. Even while capturing, they take all the screenshots have to be taken to ensure that there is no manipulation or inadvertent change. Establishes authenticity and credibility. So legal acceptability. For digital evidence to be admissible in court, it must be proven to be authentic and reliable. The chain of custody provides this proof by documenting the evidence handling. Then the trustworthiness of evidence. So well-documented chain of custody enhances the trustworthiness of the evidence, making it more likely to be accepted by legal authorities. Third is the prevents contamination and tampering. So control access. access. That is, it must be confidential by strictly controlling who has access to the evidence and documenting each access. The chain of custody helps prevent unauthorized access and potential contamination or tampering. Then traceability, that means whether we can attribute that to some person, some accountability should be there. So any anomalies or issues with the evidence can be traced back to the responsible party, ensuring accountability. See, we are not saying that it can't be tempered. What we are saying is, if there is tampering, it should be detectable. It should be detected. Then supports forensic investigation process. So consistency. Chain of custody ensures that evidence remains consistent throughout the investigation process, from collection and analysis to presentation in court. And then structured documentation. So detailed documentation helps forensic investigators understand the history and context of the evidence, aiding in thorough and accurate analysis. Then facilitates the legal proceedings. So evidence handling record, that is detailed records of how evidence was collected, transported, stored and analyzed, can be presented in court. Remember, presentation is the last stage actually. Presented in court to demonstrate that proper procedures were followed. And defense against challenges, because there could be challenges from your opponent who may be a prosecution or defense lawyer. So in legal proceedings, the defense may challenge the validity of the evidence. A strong chain of custody helps counter such challenges by proving that the evidence was handled correctly. And you already know this burden of proof, onus of proof concepts in Indian Evidence Act. Then compliance with legal standards. So adherence to regulations. So various legal frameworks and regulations require adherence to such evidence handling procedures. The chain of custody ensures compliance with these standards. Then avoidance of legal repercussions. So failure to maintain a proper chain of custody can result in evidence being deemed inadmissible, potentially jeopardizing the case and leading to legal repercussions for the investigators. Sometimes even the policemen or the forensic experts could also be prosecuted if there is tampering or manipulation detected, because it can be detected. Then professionalism. So we see it enhances the credibility of the investigation team. So professionalism is adhering to chain of custody procedures reflect the professionalism and credibility of the forensic investigation team. Then the reputation. So maintaining a proper chain of custody helps build and maintain the reputation of the investigative team and their organization. So we can conclude about the chain of custody that it is the essential in cyber forensic for ensuring that digital evidence remains intact, credible and legally admissible. It plays a pivotal role in preserving the integrity of the evidence, establishing its authenticity, preventing tampering, supporting the forensic investigation process, facilitating legal proceedings, ensuring compliance with legal standards. Standards have been mentioned in IT at Schedule A, Schedule 1, and enhancing the credibility of the investigation team. Adhering to a rigorous chain of custody process is crucial for the success of any cyber forensic investigation and subsequent legal actions. Now we are coming to the second part of my presentation, that is the changes in BNSS, because both are procedural law, as we know. BSA is actually applies to civil as well as criminal, and BNSS, Bharatiya Nagarik Suraksha Sanhita, replaces the old CRPC 1973. So these paragraph numbers are from the this parliamentary committee report headed by Brijlal, standing committee on home affairs. So according to the statement of objects and reasons, that is SOR, of the BNSS, SOR is the document that is given to the MPs and MLAs so that they know about when the bill is presented, what is the purpose of the bill. So that is called statement of objects and reasons, and courts may also refer to it as you might have studied in this interpretation of statutes subject. It proposes to repeal the CRPC 1973 and provides for the use of technology and forensic sciences in the investigation of crime and furnishing and lodging of information, service of summons, etc. through electronic communication. And the accused persons may be examined through electronic means like video conferencing. This is a revolutionary change, that is BNSS 530. We shall see that also. Second is all trials, inquiries and proceedings may be held in electronic mode. This is the second from last. There are total 531 sections, and section 530 allows all these examinations, that is examination in chief, cross-examination and re-examination. So the committee notes that the Sanhita provides for acceptance of trials in electronic mode as provided in clause 532. Now it is section 530. In bill it was 532, wherein all trials, inquiries and proceedings may be held in electronic mode by production of electronic communication devices likely to contain digital evidence for investigation, inquiry or trial. That means there will be almost no need to go to court except maybe for judges and their staff. So there have been some orders by Supreme Court that it shall be at the option of the advocates or at the option of the litigants, and even some provisions for arrest and bail might become redundant over some years because everybody can appear through their own smartphones. Electronic communication includes communication through devices such as mobiles, computers or telephone, etc. The committee notes the enhanced technological integration in the Sanhita, emphasizing encouraging increased utilization of technology in legal proceedings and considered it as a welcome change. Earlier, you might be aware that it's all started from Bihar. कैदी को इधर से उधर ले आते थे, जेल से कोर्ट तक भाग जाते थे. So they started video conferencing, and that's why some amendments were made in 2005, 2010, and now say this electronic evidence, entire proceeding can be conducted after 1st July, but the government says it might take them around 3 years, 2027, as per the statement of the Home Minister Amit Shah ji. Clause 2.4 of Parliamentary Committee report says, committee also notes that while the increased utilization of technology offers numerous advantages, it also creates opportunities for manipulation and misuse. So collection and storage of electronic evidence raises concerns about data security and the possibility of unauthorized access or breaches. The committee therefore recommends that the adoption of electronic means for communication and trials should proceed only after the establishment of robust safeguards, that is security safeguards, to ensure the secure usage and authentication of electronically available data. This will help safeguard the integrity of the justice system and ensure that justice is administered fairly and accurately. Now the video conferencing has already started in case of Supreme Court and High Court. Even the video conferencing rules have been made by many high courts under Article 227 of the Constitution. Now, how government looks to overall criminal justice system with tech-driven proposed laws. See, the three legislation meant to replace the IPC, CRPC, and Indian Evidence Act will bring far-reaching reforms and help shed colonial baggage. So the entire process from filing of FIR, that is now there are e-FIRs also, to case diaries, to charge sheet, to judgment will be digitized, and that again increases the importance of electronic evidence. Now, reforms to the criminal justice system in India. So the three acts passed by the Parliament came into effect from 1st July 2024 and are expected to bring far-reaching reforms to the criminal justice system in India, particularly the use of technology in police investigations and judicial process. And that's why I told more than 5,65,000 people have been trained in last 6 months. The new legislation aim to not only address the current challenges faced in the criminal justice system, but also incorporate critical provisions on use of technology and forensic science, besides simplifying procedures, reducing dependency of court cases, we call them arrears, strengthening prosecution, because the conviction rate is sought to be increased from 10% to 90%. That means the job of defense advocates is going to be very, very difficult under the new laws. So strengthening prosecution, increasing fines upon conviction. It has been done in many, 41 cases, offences, imprisonment has been increased in BNS, Bhartiya Sanhita, which replaces IPC, and in 82 cases the fines have been changed. Earlier it was ranging from 10 to 1,000 rupees. Now it has been increased many times, reducing crowding in correctional homes and expediting trials. Now we see the comprehensive overview that recommendations for a comprehensive review of the criminal justice system had also been made by the Parliamentary Standing Committee on Home Affairs, and there were many committees which had asked to repeal all these three laws over many years. So most of the committee's reports pointed towards inordinate delays in investigation, inadequate use of forensics in investigation as compared to, say, Western countries, particularly overcrowding of prisons, that is more under trial people rather than convicted criminals, poor use of technology in legal systems, complex legal procedures, mainly this CPC and CRPC, and huge pendency of cases, that is arrears, poor conviction rate. It was almost 10%, and former Attorney General Soli Sorabji had stated that criminal justice system in India is on the verge of collapse, because if it is 6%, then 94% criminals are roaming freely, and therefore some amendments were made in 2005, 2010, 2014, then 2018. Now the entire code has been changed. These issues ultimately caused delays in providing justice. So how this technology has been used? So use of technology, the older laws were drafted by the British to suit their interests, and it had long been felt that the country's criminal laws should address the concerns of Indian, particularly the poor and the vulnerable. Moreover, the CRPC entered very little use of technology in criminal procedures and court proceedings. See, IT Act 2000 amended only the IPC and the IEA. It didn't amend the CRPC, and therefore there was need to amend the CRPC also. So a new definition of electronic communication has been added in the Bharatiya Suraksha Sanhita bill as Section 2F to facilitate the use of technology in investigation, trial court proceedings, and other procedures. The proposed law has been made tech-friendly, and a number of measures have been taken to facilitate the criminal justice system. Now, the entire process from filing of FIR to case. See, when we talk of digitization of processes, how BNSS is going to change the older methods. So from filing of FIR to case diary to charge sheet to judgment will be digitized. Technology will be used by the police while conducting search and seizure. Compulsory videography provision has been made, and it has to be transmitted to the magistrate on the same day. The whole process of searching a place or taking possession of any property, including preparation of a seizure list and signing of the list by witnesses, shall be videographed on an electronic device, including mobile phone, by the police. Such recording shall be forwarded without delay to the concerned magistrate. Then we see use of forensic science in investigation. investigation. So if there is punishment for 7 years or more, then there is compulsory forensic investigation. So the proposed laws have given due importance to the use of forensic science in investigation, and unless forensics is used, it will not be possible to secure a conviction rate of more than 90% in India. See, from 10%, the vision is to increase it to 90%, and therefore I told that the job of defense lawyers is going to be very, very difficult, and for prosecution it is going to be going to be easier. And if this conviction rate has to be ensured, then importance of forensic expert or the expert evidence under BSA 39 is going to be increased drastically. So due emphasis has also been given to strengthening forensic science infrastructure in all states and UTs. Actually, the government has projected that there will be demand of 35,000 forensic experts over the next 5 years, and 6 forensic science universities have been established. So besides the Central Forensic Science Laboratory and the State Forensic Science Laboratories and the 40 labs of CSIR, now there are Council for Scientific and Industrial Research, there are going to be at least 3 mobile forensic vans in every district as per this new provision. To improve the conviction rate, the use of forensic experts will be made compulsory in all cases where there is provision of jail term of 7 or more years. So this has been given in BNSS. We shall see the provisions also. Now the features are digitization of complete process starting from registration of FIR, that is there is electronic FIR, and that has to be confirmed within 3 days, to maintenance of case diary CD, or to filing of charge sheet and delivery of judgment. Complete trial including cross examination, appeal to be facilitated via video conferencing. This is given in 530. And videography while recording statement of victims of sexual crimes mandatory. Then judgment to be mandatorily made available online within 7 days of pronouncement, that is uploading on website. And videography mandatory during section the search and seizure. And videography of vehicles seized for involvement of any offense is mandatory, whereafter a certified copy will be submitted to the court to ensure to enable disposal of seized vehicle during pendency of trial. All this emphasizes the importance of the cyber forensics and forensic evidence. Forensic teams to mandatorily visit crime scenes for offences involving punishment more than 7 years, and deployment of mobile forensic science laboratories at district level. And no case punishable with 7 years or more shall be withdrawn without providing opportunity of hearing to the victim. These are the changes. Now, if we see, firstly, the videography of search and seizure operations. So it mandates the videography of search and seizure operations, ensuring transparency and adherence to procedures as per section 105 of BNSS. Then integration of technology in legal processes. So Sanhita introduces the use of technology in various legal proceedings such as serving summons, notices and warrants. Now they can be sent by email, WhatsApp, सब कुछ तरीके से भेज सकते हैं, नहीं गए तो फिर पुलिस आ जाएंगी. So such as serving summons, notices and warrants electronically, enhancing efficiency and including paperwork, reducing paperwork. So section 63(2) sexual crime से related जो chapter 5 है BNS का, this is BNSS. So section 63(2), 64(2) proviso, 70 subsection 3, 71 subsection 1, 71 subsection 2 and 94 subsection 1. So these are the provisions under the BNSS. Then we see forensic evidence collection for serious offences. So it mandates forensic teams to visit crime scene to collect evidence in offences punishable to imprisonment of 7 years or more. This is given in 176 subsection 3. Then we see informing the informants and victims about progress of investigation. So BNSS requires police officers to inform informants जो FIR लिखवाता है and victims, they could be same or different persons, about the progress of investigations including through digital means. Section 193 subsection 3 clause 2. Then we see recording statements through electronic means. So this can be done. So BNSS permits the recording of statements through electronic means, enhancing convenience and accuracy. Section 530. Then sampling for investigation without arrest. I have already told that arrest will be unnecessary in many cases, and even the provisions for arrest and bail may become obsolete over say next few years. So it introduces provisions for collecting samples for investigation without the necessity of arresting the accused. That is in section 349. Then the time limits for pronouncing judgments and online publication. So Sanhita mandates specific time limits for pronouncing judgments and promotes online publication or transparency. This is in section 392 subsection 1 and 4 of BNSS. Now we see what are the new sections. As far as what is relevant for our electronic evidence topic, 105, that is recording of search and seizure through audio, video, electronic means. Then 336, evidence of public servants, experts, police or officers in certain cases. And 530, that is trial and proceedings to be held in electronic mode. So these are the new sections that are relevant for our today's discussion. First we see what is the definition of audio, video, electronic means. There is a new definition under section 2. So in this Sanhita, unless the context otherwise requires, audio, video, electronic means बहुत जगह पर आया इस कोड में, shall include use of any communication device for the purpose of video conferencing, recording or processes of identification, search and seizure of evidence, transmission of electronic communication, and for such other purposes and by such other means as the state government may by rules provide. So state government may even make the rules for this audio video electronic means, because the technology changes. Then clause I, electronic communication. It means the communication of any written, verbal, say pictorial, automation or video content. That is, see, all the things are included: text, picture, audio, video, multimedia we call it in computer engineering. So our video content transmitted or transferred whether from one person to another or from one device to another or from a person or a device or from a device to a person by means of an electronic, because it could be automated system also, by means of an electronic device including a telephonic, mobile phone or other wireless communication device or a computer or audio video player or camera or any other electronic device or electronic form as may be specified by notification by the central government. Then what's this is very important, subsection 2. So subsection 2 of section 2 says words and expressions used herein and not defined but defined in the Information Technology Act 2000 and the Bharatiya Nyaya Sanhita 2023 shall have the meanings respectively assigned to them in that Act and Sanhita. So these definitions under IT Act and BNS have to be referred to if something is not clear in BNSS. Then 105, recording of search and seizure through audio video electronic means. Now see, this is compulsory, a new provision. So let us read what it says. The process of conducting search of a place, जिसको हम raid बोलते हैं, search of a place or taking possession of any say property, article or thing under this chapter or under section 105, 185, including preparation of the list of all things seized in the course of such search and seizure and signing of such list by witnesses shall be recorded through any audio video electronic means, preferably mobile phone and the phone होना चाहिए, and the police officer shall without delay forward such recording in the district magistrate, subdivisional magistrate or judicial magistrate of the first class. Then section 173, this information in cognizable cases, this corresponds to CRPC 154 FIR. So this says every information relating to the commission of a cognizable offense irrespective of the area where the offense is committed may be given orally or by electronic communication. This is very important provision, or by electronic communication to an officer in charge of a police station, and if given orally it shall be produced by writing by him or under his direction shall be and be read over to the informant, and even such information whether given in writing or reduced to writing as aforesaid shall be signed by the person giving it. Secondly, by electronic communication, it shall be taken on record by him on being signed within 3 days by the person giving it. That means within 3 days the person will have to go to police station and give it in writing, and the substance thereof shall be entered in a book to be kept by such officer and in such form as the state government may by rules prescribed in this behalf. This is a very long section. We shall not go to all 173 but only relevant. Provided further that in the event that the person against whom an offense under section 64, section 65, that is offense against women, we can say chapter 5 of BNS, section 65, section 66, 67, 68, 69, 70, 71, 74, 75, section 76, 77, 78, 79 or section 124 of the Bhartiya Nyaya Sanhita 2023 is alleged to have been committed or attempted, is temporarily or permanently mentally or physically disabled, then such information shall be recorded by police officer at the residence of the person seeking to report such offense or at a convenient place or such a person's choice in the presence of an interpreter or a special educator as the case may be. So it is very convenient particularly for women victims of sexual offenses because this provision of EFIR is also now there. The recording of such information shall be videographed. See, B says that it will be videographed, again creating new digital evidence, electronic evidence. The police officer shall get the statement of the person recorded by a magistrate under clause A of subsection 6 of section 183 as soon as possible. This corresponds to our older 164. Then 187.4. So procedure when investigation cannot be completed in 24 hours. So no magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remains in the custody of the police. But the magistrate may extend further detention in judicial custody on production of the accused either in person, see, this is very important, or through the audio video electronic means. That means accused can be produced before the magistrate through audio video electronic means. So audio video conferencing bhi kara sakte hai. This is very important. Next we see 187.5. Procedure when investigation cannot be completed. We see subsection 5. No magistrate of the second class not specially empowered in this behalf by the High Court shall authorize detention in custody of the police. Explanation 1 says that for the avoidance of doubts, it is hereby declared that notwithstanding the expiry of the period specified in subsection 3, the accused shall be detained in custody so long as it does not furnish bail. Explanation 2 says if any question arises whether an accused person was produced before before the magistrate as required within subsection 4, the production of the accused person may be proved by his signature or the order authorizing detention or by the order certified by the magistrate as to production of the accused person through the audio, video, electronic means. Again, these words have come through audio, video, electronic means, as the case may be. Then we see 336, that is evidence of public servants, experts, police officers in certain cases. This is analogous to this BSA 39, that is Indian Evidence Act 45. So where any document or report prepared by public servant, scientific expert, medical officer or investigating officer is purported to be used as evidence in any inquiry, bail or other proceeding under this Sanhita, and such public servant, expert or officer is either transferred, retired or died, or such public servant, expert or officer cannot be found or incapable of giving deposition. This might answer many of your doubts and questions. Or securing presence of such public servant, expert or officer is likely to cause delay in holding the inquiry, trial or other proceeding. The court shall secure presence of successor officer, जो उत्तरवर्ती ऑफिसर है उसका उत्तराधिकारी ऑफिस में उसका एविडेंस माना जाएगा. So successor officer of such public servant, expert or officer who is holding that post at the time of such deposition to give deposition on such document or report. That means if somebody has retired, died or not available or transferred, then that won't affect the proceedings. It can be completed by successor. This is the one of the most important sections in BNSS. There are 531 sections. 530 says all trials, inquiries and proceedings under this Sanhita, including issuance, service and execution of summons and warrant, examination of complainant and witnesses, that is all the three examinations, examination in chief, cross-examination and re-examination as given in BSA, recording of evidence in inquiries and trials, and all appellate proceedings or any other proceeding that includes appeal, revision, reference review, all these things can be done, shall be held in electronic mode by use of electronic communication or use of audio, video, electronic means. It says may be held. That's why the government says it might take about 3 years, because all the computers have been, all district courts have to be computerized, and if they are available in criminal courts, maybe that would enhance the speed of justice in civil courts also, because they can be used in civil proceedings also in future. Now the role of digital evidence in cyber forensic investigation. So now again we we have completed this BNSS. We shall see what is the role of digital evidence. It plays a crucial role in cyber forensic evidence investigations, and we shall see what are the stages. So it involves the collection, preservation, analysis and presentation of data from digital devices to support or refute hypothesis about an incident or crime. So here are the key aspects of its role. First is the identification and collection, because see, all investigation is साक्ष्य एकत्रित करना. So that is to be done by the police under chapter 12. पहले भी chapter 12 था, now also it is chapter 12 under BNSS. So detection of incidents, that is digital evidence, helps in identifying the occurrence of a cyber incident. Logs, alerts and other digital footprints are critical in detecting unauthorized activities. Then acquisition of evidence. So forensic experts collect digital evidence from various sources such as computers, mobile devices, servers, network devices and cloud services. This process must ensure the integrity of the evidence is maintained. Then maintaining integrity, preservation. So it's crucial to preserve digital evidence in original form. This involves creating exact copies, that is bit by bit images of storage devices, and using say wide blocker to prevent alteration of write blockers to prevent alteration of original data, ताकि copy करते हुए change ना हो जाए. Then chain of custody, this we have already seen in detail. Documenting the handling of evidence from collection to presentation in court to ensure its authenticity and admissibility. Then data examination. In analysis, we see data examination. Forensic analysis scrutinize the collected data to uncover relevant information. This may include analyzing file systems, recovering deleted files, examining logs, and identifying hidden or encrypted data. Reconstruction of events. By analyzing digital evidence, investigators can reconstruct the sequence of events. वो जो chain of events करना पड़ता है, Indian Evidence Act Section 3. Can reconstruct the Section 6. Can reconstruct the sequence of events leading to the incident, determine the extent of the breach, and identify perpetrators and understand their methods. That is modus operandi of criminals. Then correlation and attribution. So linking the evidence, because for establishing the chain under Indian Evidence Act Section 6, this linking has to be done, or there has to be primary, secondary, oral, documentary, electronic, and corroborating evidence. So digital evidence from different sources can be correlated to build a comprehensive picture of the incident. For example, correlating network logs with user activities to say pinpoint the source of an attack. For example, somebody deletes email from his or her computer, then the maybe Gmail or other certifying authority or say this intermediary can be contacted for corroboration that they have deleted and the email was sent or not sent. So that this is called non-repudiation under cybersecurity. Identifying the suspects. So analyzing digital footprints can help attribute actions to specify individuals or groups. This includes tracing IP addresses, examining user user accounts and analyzing communication patterns. So this is how they identify the suspects. Then presentation, that is in court. So reporting. So forensic investigators compile their findings into detailed reports. These reports must be clear, accurate, and comprehensive, often including timelines, data visualizations, and expert interpretations. And finally, there is court testimony. So digital evidence must be presented in a legally admissible format after the summons come under section 39. So forensic experts may testify in court to explain their findings and the methods used to collect and analyze the evidence. So they have to explain it to police, prosecutors, defense lawyers, and judges, etc. Then legal and ethical considerations are compliance with laws. So handling digital evidence must comply with relevant laws and regulations to ensure its admissibility in court. This includes understanding jurisdictional issues and privacy laws. Ethical standards, that is, forensic investigators must adhere to ethical standards, ensuring impartiality, confidentiality, and integrity throughout the investigation process. Then we can conclude that digital evidence is fundamental to cyber forensic investigations, providing the necessary data to understand, respond to, and mitigate cyber incidents. And proper handling, analysis, and preservation of digital evidence are essential to uncovering the truth and ensuring justice. This completes our second act, that is BNSS. Third is IT Act. So this discussion would be incomplete without considering the Information Technology Act. Of course, I will consider only few relevant provisions. Let us see the structure. Preliminary sections 1 and 2 for those who are not familiar with that. Section 2 says about digital signature and electronic signature, that is sections 3 and 3A inserted through amendment in 2008. Electronic governance, that is sections 4 to 10. Very important chapter 3, because it says what is valid, what is not. Chapter 4 is we shall see chapter 3 in detail. Attribution, acknowledgement, and dispatch of electronic records, that is sections 11 to 13. Chapter 5 is about secure electronic records and secure electronic signatures, sections 14 to 16. Chapter 6 is regulation of certifying authorities, sections 17 to 34. Certifying authorities are like VeriSign, MasterCard, Visa, Google, Facebook, or even say Paytm, Google, GPay. These could be certifying authorities. So they are given license by the control of certifying authorities with a government institution. So regulation of certifying authorities is sections 17 to 34. Electronic signature certificates, sections 35 to 39. Duties of subscribers, that is sections 40 to 42. That is, they give their correct records. Chapter 9 is very important as far as cyber crimes is there. Penalties and adjudication, that is sections 43 to 47. 11 is about offenses. 10 is the appellate tribunal. Earlier it was called cyber appellate tribunal. The word cyber has been dropped by the Finance Act 2017, and now the same tribunal, that is TDSAT, Telecom Dispute Settlement and Appellate Tribunal under the Tri-Act, Telecom Regulatory Authority Act 1997, because the mobile services themselves have become, the mobile companies themselves has become the internet service provider, that is the ISP, and therefore there is a common tribunal now. So this same TDSAT is called as Appellate Tribunal when it works under the IT Act. So Cyber Appellate Tribunal has been renamed in 2017. Sections 48 to 64, many of which have been deleted because they were redundant. Offenses, this decides most of the types of cyber crimes. So almost all cyber crimes are given in section 43 and in section 65 to 78. Chapter 12 is the intermediaries not to be liable in certain cases, section 79. So it exempts say like Facebook, YouTube, or say intermediaries for the ads done by their by public. Chapter 12 is about it establishes this examiner of electronic evidence, section 79A. Chapter 13 is miscellaneous, that is sections 86 to 80 to 90. 91 to 94 have been deleted because those were already incorporated. That is as per the provisions of this General Clauses Act 1897. Then Schedule 1, documents of transactions to which the Act shall not apply. So where IT Act does not apply, manually क्या करना जरूरी है, that is mentioned in Schedule 1. And Schedule 2 describe electronic signature or electronic authentication technique and procedure. So what are the valid algorithms? We talked about SHA1, SHA 256. So these have been listed under Schedule 2, and this can be changed by central government from time to time. Now coming to digital signature and electronic signature. See, the government itself had defined it wrongly in the original Act of 2000, and that was not in the sense in which the cryptographers or the international definitions were there. Therefore, these were amended in the Amendment Act 2008, and now digital signature is different from electronic signature. So digital signature is a bit string, binary 0 or 1 होते हैं उसमें, very long string. So that is unique for different persons, different authorities. So because crores of people are working on e-commerce using e-transactions for online shopping, etc. So digital signature means authentication of any electronic record by subscriber by means of an electronic method or procedure in accordance with the provisions of section 3. And digital signature certificate means a digital signature certificate issued under subsection 4 of section 35. Next is electronic record, means data record or data generated, image or sound stored, received or sent in an electronic form, microfilm or computer generated microfiche. Film continuous होती है if it is cut into many pieces frame by frame, that is microfiche, like cinema films. Electronic form, so with reference to information means any information generated, sent, received or stored in media, magnetic, optical, computer memory, microfilm, computer generated microfiche or a similar device. And electronic gazette means official gazette published in the electronic form. These all electronic gazettes are also valid. Then electronic signature. So electronic signature means authentication of any electronic record by subscriber by means of any electronic technique. For example, if you are signing on a check and you are making image of that check, then the bank teller might compare it manually or by using software. That is electronic signature. It is not digital signature specified in the second schedule and includes digital signature. See, the definition is electronic signature includes digital signature. So digital signature is a bit string of maybe 128 bit, 256 bits, or say 512 bits. That is a unique binary string given to every person, every subscriber. And electronic signature includes digital signature. So if you are taking photograph of your manual signature, that is electronic signature, but it is not digital signature. Then electronic signature certificate means an electronic signature certificate issued under section 35 and includes digital signature certificate. This change came into effect in 2009. That is by IT Amendment Act. Now this chapter is very important, chapter 2, digital signature and electronic signature. So this chapter has only 2 sections, that is 3 and 3A. It provides the condition subject to which an electronic record may be authenticated by means of affixing digital signature. So digital signature is created in 2 distinct steps. First, the electronic record is converted into a message digest by using, this is what is MD5 algorithm or MD4 algorithm that was older, by using a mathematical function known as hash function, which digitally freezes the electronic record, thus ensuring the integrity of the content of the intended communication contained in the electronic record. We talked about hash value. So hash function is mathematical function that is used. Any tampering with the contents of the electronic record will immediately invalidate the digital signature. Secondly, the identity of the person affixing the digital signature is authenticated through the use of a private key, which attaches itself to the message digest and which can be verified by anybody who has the public key corresponding to such private key. That is, this is called the data origin authentication. Message bheja kisne hai. Second is data authentication. That is whether there is any tampering or not. So who has sent can be authenticated, and what has been said, that can also be authenticated. So this will enable anybody to verify whether the electronic record is written intact or has been tampered with since it was so fixed with the digital signature. It will also enable a person who has a public key to identify the originator of the message. This is part of asymmetric cryptography, which we teach to final year computer students. Now the authentication of electronic records. What the law says, IT at subsection 1 of section 3. Subject to the provisions of this section, any subscriber may authenticate an electronic record by affixing his digital signature. The authentication of the electronic record shall be effected by the use of asymmetric crypto system and hash function, which envelop and transform the initial electronic record into another electronic record. Explanation says, for the purposes of this subsection, hash function means an algorithm mapping or translation of one sequence of bits into another, generally smaller, such set known as hash result, such that an electronic record yields the same hash result every time the algorithm is executed with the same electronic record as its input, making it computationally infeasible. I will explain it. See, we are familiar with the concept of notarization. What this notary or notary public did, they were advocates with 7 years experience, and they count the number of words that are written in, for example, a will, wasiyatnama, or say for any deed that is executed, and they write. That was when the manual handwriting was prevalent. Then came the computers. So now there cannot be any manipulation without use of computer, because that can be very easily detected. So nowadays they don't count. But earlier there was this concept of notarization. We can consider this as a e-notarization, electronic notarization process. So to derive or reconstruct the original electronic record from the hash result produced by the algorithm, that 2 electronic records can produce the same hash result using the algorithm. That means that's why if any tampering or manipulation is done, it can be detected. We can't say it cannot be done. What we are saying is it can be detected. So authentication of electronic records, any person by the use of public key of the subscriber can verify the electronic record that it is sent by a particular person. The private key and the public key are unique to the subscriber and constitute a functioning key pair. Maybe say 2 prime factors of a composite number, and that's why there is too much mathematics involved in it. Then electronic signature. This is a new section added in 3A in 2008, which came into effect in 2009. So notwithstanding anything contained in section 3, but subject to the provisions of subsection 2, a subscriber may authenticate any electronic record by such electronic signature or electronic authentication technique which is considered reliable and may be specified in the second schedule. And second schedule gives all the cryptographic algorithms that are valid or recognized in India. Then subsection 2 says, for the purposes of this section, any electronic signature or electronic authentication technique shall be considered say reliable if the signature creation data or the authentication database data are within the context in which they are used linked to the signatory, or as the case may be, the authenticator and of no other person. That means they can be uniquely attributed to the creator, just like manual signature. Signature is a type of behavior in biometrics. The signature creation data or the authentication data were at the time of signing under the control of the signatory, or as the case may be, the authenticator and of no other person. That means he was himself in possession of that signature. Any alteration to the electronic signature made after affixing such signature is detectable. See, we are not saying it cannot be done. It can be done, but if it is done, it is detectable. Any alteration to the information made after its authentication by electronic signature is detectable. That means if information, there is alteration of electronic signature, that is detectable. Alteration of information is also detectable, and it fulfills such other conditions as may be prescribed. That is by rules. Now, the central government may prescribe the procedure for the purpose of ascertaining whether electronic signature is that of the person by whom it is purported to have been affixed or authenticated, and the central government may, by notification in the official gazette, say add or omit or electronic signature or electronic authentication technique and the procedure for affixing such signature from the second schedule, provided that no electronic signature or authentication technique shall be specified in the second schedule unless such signature or technique is reliable. So central government can amend the second schedule, and every notification issued under subsection 4 shall be laid before each house of parliament. That is the procedure. Now, chapter 3 is electronic governance. The time is 5:17 already, so I will not go to section by section reading, but I will just explain the titles of these sections. This is very important. 4 to 10A. Section 4 says that legal recognition of electronic records. See, this recognizes electronic records. Then we see that means all electronic records are valid and they are legal. This is declared in section 4. Second is legal recognition of electronic signature. See, 4 was about electronic records. 5 is about electronic signature. They are also all valid if they are issued by the signature certifying authority under the IT Act. Then use of electronic records and electronic signature in government and its agencies. This facilitates e-governance. So because there was reluctance to adopt e-commerce, particularly by the government agency and the recognition, therefore 6 recognizes this in all government correspondence. Then section 6, subsection 2, then there is delivery of services by service provider. See, why this is given? Because what will people without internet, without electricity will do? So this delivery of services can be done by service provider. That means the central or state government may authorize the use of cyber cafes where services are available on payment, and people who are without internet, without smartphone or without electricity can go and make the payment and use such services. To facilitate that, 6A was introduced in 2009. So for that, the rules can be made by appropriate government. Then there is 7, retention of electronic records. That is how long the records shall be retained. So this is there. There is another act that is passed now, that is DPDP Act, Digital Personal Data Protection Act 2023. Maybe we may hold some another session on that. So this is about retention of electronic records. Section 8 is about audit of documents, etc. in electronic form. That is for audit purpose, financial audit, cash book, everything maintained on computers can be valid for audit purpose also. So a new section was added because there are difficulty faced in audit. Then there is 8, publication of rules, regulation, etc. in electronic gazettes. 8 says that gazettes are valid. That is, all electronic gazettes are valid. So this is validity of electronic gazettes as per section 8. Section 9 says that section 6 and 8 not to confer right to insist documents should be accepted in electronic form. See, citizens can't insist that government should do a particular thing in electronic form. So 9 says that it will be as per the resources of the government, and government may gradually computerize the processes. So citizens can't insist on particular document should be accepted in electronic form. Then the government can okay, that is in 10A. So power of to make rules by central government in respect of electronic signature. So this is the rule making power of central government as far as electronic signature is concerned. Then validity of contracts formed through electronic means. See, there is also in this section 9 we have seen that this government can make something compulsory. That is, they can make it gives the right to the government to make something that, like income tax e-filing. They have made e-filing compulsory. So government can make something compulsory, but citizens can't insist. So government can make a rule that manual system shall be abolished, like they have done in case of attendance, that biometric attendance is compulsory. So government can make any electronic thing compulsory, abolishing the manual things, but the citizens can't do it. And section 10A says validity of contracts formed through electronic means. So this gives recognition to electronic contracts, maybe smart contracts or blockchain technology nowadays that is used in cryptography. Coming to the offenses, I'm not going into details, but only section 65, tampering with computer source documents. This is a cybercrime offense. So whoever knowingly or intentionally conceals, destroys or alters, or intentionally or knowingly causes another to conceal, destroy or alter any computer source code used for a computer program, computer system or computer network, when the computer source code is required to to be kept or maintained by law for the time being force shall be punishable with imprisonment up to 3 years or with fine which may extend up to 2 lakh rupees or with both. Many cyber offenses are there, so I will not go into details of that. There is examiner of electronic evidence. So this is chapter 12A. It contains only one section inserted through amendment. So central government to notify examiner of electronic evidence. So central government may, for the purposes of providing expert opinion on electronic form evidence, this is just like GEQD, government examiner of question documents. Before any court or other authority specify by notification in the official gazette any department, body or agency of the central government or state government as an examiner of electronic evidence. And explanation is, for the purposes of this section, electronic form evidence means any information of probative value that is either stored or transmitting in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines. So that concludes this presentation.
Thank you so much, sir.
So you may ask questions related to any area. I'm a computer engineer, lawyer, and a criminologist also. So we can examine it from any angle. We can go into technical or legal details of any doubts that you may have. What in case the file is deleted? See, when the file is deleted, actually the file does not get deleted. Now that may sound very strange, but only the name of that file is deleted from the records. And then the file can be, recovered like by using Recuva software or many other, software and hardware techniques are there. So even all the deleted data can be recovered, but it depends how much time has passed after the data was deleted. So deleted data can also be recovered very easily. So this is normally all computer engineers or recovery specialists can do, and even the recovery specialists that can do it may charge, say, thousands or lakhs of rupees even from mobile phone. If the data is deleted, that can be recovered. So that is possible because when there is something called file allocation table, FAT. So that entry in FAT is deleted. The file actually does not get deleted. So only the reference to the file gets deleted, and therefore the operating system does not leach that file, but actually the value bit by bit file is there. This is just like tearing of an index of a book. So if the index is torn from that book, you can reconstruct the index from that original book because the paragraphs and all the text is written there already. So it is not bit by bit erasure. But if it is bit by bit erasure, then it becomes very difficult to recover such a file in case of deletion. So I will not go into technical details of that, but just remember that when a file gets deleted, it normally does not get deleted. And for secure delete, there are many complicated software like CCleaner or some secure delete algorithms are there. So complete deletion can also be possible, and that can be done through some cryptographic algorithms. Another question is, will there be a detailed discussion about Information Technology Act? Yes. I have actually today itself I have another presentation from 6 to 7 that is being conducted by Progress Academy. So that is on IT Act. Earlier I had held one presentation some 3 years before for assistant candidates, that is advocates preparing for assistant prosecuting officer APO exam of Madhya Pradesh. Over 400 advocates were there in Zoom meeting. So maybe we can hold on IT Act also. That is one of my favorite topics, and we have been teaching that to engineering students in this e-commerce as well as now in cyber security subject. So it's also very important as far as the cyber law is concerned. See, the government is proposing to repeal that act by Digital India Act. Maybe it might be bill may be published by the government on 2024 this year itself. So maybe you can watch the MeitY website, that is Ministry of Electronics and Information Technology. So that is supposed to repeal this Information Technology Act 2000. But it is very relevant. It is a very big act, and maybe we can have one full session on that. So, but if there are any questions related to that, I already have my presentation ready. So you may go, if you have any specific query, you can ask me. Maybe I can answer that. Another question in chat box is, what will be complementary course to cyber laws? Well, generally there are certificate or diploma courses, and cyber law is also an say elective or compulsory courses in some of the law LLB courses, particularly in the NLUs. So those who want to opt may opt for the cyber law subject. So that is now possible. It is a cyber law, cyber crime, cyber security. So it is very important. Particularly cyber law is relevant even to civil cases as well as the criminal cases. So that is very important field of specialization. Sir, can a common citizen of this country hold e-signature? Please tell under which rule and law with process. Very simple. See, you are making payment by GPay. That is say for financial transaction. What you are doing is you are using that electronic signature. It is also there are various methods of authentication. Some are digital, digital signature. Some are related to electronic signature. Whenever you are doing net banking or etc. See, there is authentication, and it is called 1F, 2F, 3F. What is this? 1 factor, 2 factor, 3 factor. 1 factor is there are 3 factors in authentication. First is who you are. Who you are is आपकी identity. आप कौन है? So who you are is your biometrics. Biometrics may include your retina scan, face, handwriting, thumb impression, iris scan, lip scan, many others. things. Maybe your palm print. These are biometrics. Second is your behavior. Behavior क्या है? Behavior is typing, speaking, your gait, manner of walking, your signature. All these are behaviors. So this is who you are. Second is what you possess. What you possess, आपके पास क्या है? That is your say credit card, debit card, identity card, ATM card, say many other library card, many other cards are there. So PAN card, Aadhaar card, all these are what you possess. Third factor is what you know. What you know is your password. That is PIN. PIN is personal identification number or password, passcode, or some code word that you know. So see, normally 3-factor is stronger than 2-factor. 2-factor is stronger than 1-factor. So for example, how do you withdraw the money from ATM? It is a 2-factor because first you should have you should be in possession of your card. Secondly, you must know the PIN number, and if you type more than 3 times, it will be blocked because there could be brute force attack. That is, person can try all permutations and combinations, and therefore you can try only 3 times. So it is a 2-factor authentication. Plus remember there is 3-factor also because there is CCTV that is monitoring. For example, if you allege वे मेरे अकाउंट से पैसा तो डेबिट हो गया बट मशीन में से नहीं निकला, how do they say investigate such complaints? So maybe you have to inform within 24 or 48 or 72 hours as per your bank rules, and then they go through that whether the cash is surplus or like that, and they know if there is any discrepancy, so that can be immediately rectified. So 3-factor is now there is also say OTP, one-time password. So for example, you are saying that this is particularly your email address. कैसे बता सकते हैं आपका email address है किसी और का है? So they will send an OTP on that email address, and once you write that OTP within specified time before the timeout is done, then they can be sure that you are it is your email. So this is they are sending you via second channel. So it is a 2-factor authentication. Suppose you are writing mobile phone number. Mobile phone number आपका है किसी और का है, कैसे पता चलेगा? So what they do is they will send you an OTP on that mobile phone number. This is a 2-factor authentication. So say these are the secure techniques that we are using, and therefore they are using generally 2-factor or 3-factor authentication rather than simple 1-factor authentication, and thus they can be sure. So everybody is using. See, all people, all crores of people have their signatures, and these signatures are given to you when you register yourself on Google Pay, net banking, or all these are certifying authorities recognized. Even MasterCard, various and foreign certifying authorities can be also recognized by the government of India. Another question is, hello sir, I am a third student, sir. Can you tell us how diploma in cyber law helps in digital evidence it is? Yes, surely, because see, there, as I told, there will be tremendous scope for prosecution lawyers as well as defense lawyers, particularly those who are well versed with electronic evidence and cyber law, cyber crime. So, and there are many diploma courses also. So maybe I'll give my contact information, and I'm not naming any specific academy or specific course, but there are such courses that are running. Even you can search yourself on internet, and such short-term courses, generally 6 months, 1 year diploma courses are there, and post LLB diplomas are also there. So after your LLB, definitely you can specialize in that. How to pursue a career in cyber security lawyer? See, for a career, firstly you should have qualification. Secondly, you should have interest in that area, and then it becomes specialization once you start getting those types of cases. So when you have some knowledge about computer technology and other things, so lawyer can also come to technology, and technology. See, I am a computer engineer. Then I came into legal field. So at present, I am a non-practicing advocate. So I am teaching to LLB students as well as the engineering students. So this can become a subject of specialization, and say you can make a career in cyber security lawyer also, as well as forensic forensic expert. Next, last question is, there is one more. Sir, please share your view on CFCFRMS, Citizen Financial Cyber Fraud Reporting and Management System. See, there are many such reporting systems. एक है cybercrime.gov.in. Now, just like in case of cyber fraud or online crimes, you can report to government agencies. They immediately take action, and you of course have to give your age. 18 साल से छोटा नहीं होना चाहिए आपका. You have to give your Aadhaar card and numbers, your mobile, email ID, and some screenshots of the offense that is alleged. So this cybercrime.gov.in does, and now all these things have been made available. There are many systems. There is one is ICJ, that is integrated criminal justice system, by all police courts and jails have been connected. As far as cyber crime is there, so 1930 helpline is there, so you can phone on 1930. There is also this system that you have mentioned, that is CFC FRMS. So this system is there under IT Act. There are for emergency, that is cyber war or cyber terrorism cases. There is also CERT-IN, that is Computer Emergency Response Team of India. So Computer Emergency Response Team has some war-like power. They can confiscate, they can take into custody anybody's computer, they can shut down any network, and they can do whatever they want is necessary for maintaining the security of the internet, because the internet was started in 1967, so that if there is third world war, then the communication among the public should not stop, and that's why the internet came into being in 1967. So all these emergency power powers have been given to the CERT-IN, that is the Computer Emergency Response Team of India, that is recognized under the IT Act. So you can go through 79A, 79B. So IT Act gives the details of these various authorities that have been established. There is compensation that can be paid by the adjudicating officer. For criminal offences, there is this appellate tribunal that was earlier named as Cyber Appellate Tribunal. So many, and there is also this examiner of electronic evidence. There is also certifying authority. There is also controller of certifying authorities. So many authorities have been created under the IT Act, and now under the DPDP Act, Digital Personal Data Protection Act of 2023, Data Protection Board of India will also be established once the rules have been made. That has already been passed, and it will come into effect very soon. And it has the powers to impose fine of 250 crore, and which may also increase up to 500 crore rupees. So that DPDP Act is there. There is the first privacy law, comprehensive privacy law of India, just like GDPR, General Data Processing Regulations of European countries. So these are some major changes. Even the Telecommunication Act has come into force of 2023 has come into force this year. So the older act, like the Post Office Act 1899 and older this Act of 1885 have been repealed, and many new changes have come in 2023. And once this Digital India Act replaces IT Act, this the 3 Act related to telecom by the MeitY, that is Ministry of Electronics and Information Technology, will be completed, and they will completely come into effect. So that process is going to happen over the next few months. Any other question?
Good evening, sir. Am I audible? Thank you for an excellent session. Sir, I have a very specific question with respect to the certificate.
Yes.
Now that there are 2 parts, Part A and Part B,
yes.
My question is whether Part B is mandated, meaning if I am the owner of the digital device in which I have recorded the evidence and I am producing certificate A because I have the device, I have recorded the material, and I am submitting to the court with my authentication. Now, in what circumstances Part B becomes mandatory for submission before the court? That is my question, sir. Thank you.
Well, actually, it is just the certificate has to be submitted in 2 parts. So both the parts are essential now. See, even that can be done by policemen, because nowadays the police constables or even these people are being told how to generate the hash values. And when they themselves are submitting. So part A is by the party who is doing it. Policemen may record, say, search and seizure, or any party may record. And then they have to obtain this certificate, and even the services may be commercially available in future. That means you have to generate a hash value, just a digital signature hota hai. You can get your digital signature from any. For example, you want to file your income tax return, or say you want to say you are a principal of a school and you are submitting some data for, say, recognition or approval of your school to the regulatory authorities. So how do they verify that you are a principal? So what they do is they give you digital or electronic signature. So you have to pay a small fees for that, and then they give the services to you. It is just very simple procedure, like in case of, say, electronic transactions. That is just like you authenticate and register yourself on GPay or say this net banking or other processes. So like that, this process will be there, and you can get your very readily obtained by paying the fees, your digital and electronic signature. And these certifying authorities are already recognized under the IT Act. So these certifying authorities can also certify your record. So you may obtain the services commercially, and even ordinary citizens, suppose there is some recording, that means there is some offensive call and you have recorded it and you want to produce it as an evidence. So you can get it authenticated, so that after you submit it to the police authorities, you can be sure that it has not been manipulated. That is because see, you have acquired that, you have collected, you have recorded that evidence. So after acquisition, there should not be any tampering, because see, tampering can be done by police officer, tampering can be done by prosecutors. So that complete chain of custody has to be maintained, and therefore these services will be available in for future in common man also, just by paying a nominal fees to your, say, certifying authorities. So certifying authorities have already been given these powers under the IT Act. So I think that should not be a problem.
Sir, if I may ask a subsequent question.
Yes.
For example, let's say I have a civil litigation with respect to a property, say for example a tenancy matter, and there is an allegation and a remedy sought for trespass as well as harassment. Now, if the victim or the plaintiff records certain information on his phone, and now he wants to present this evidence to the court that such and such person has been causing so much of harassment to me, and I seek remedy from the court. Now, in this case, whatever evidence that the person has collected in his digital phone, is that person required to first approach the authority and obtain the Part B also from that authority and present Part A as well as Part B to the court himself? itself, or can that person request the court to instruct the authority so that part B also can be produced by such an authority?
No, see, when the state is a party, that is in criminal cases, the state is necessarily a party because all criminal action is taken in the name of the state. But in civil cases, it is the duty of the person because see, 65B was already mandatory. See, 65B section पहले भी था Indian Evidence Act में. Now it has been replaced by 63. So under section 63, this has to be executed, and this is in two parts because there is some case law. I have come across some judgments where the electronic evidence is rejected because it was not supported by the expert, say forensic expert or electronic expert. So there has to be expert also to validate that. That is to certify. This is called as trusted third party because see, when the litigating parties are there in a case, so naturally they are doing that in their interest. So this certifying authority has to prove the genuineness of the evidence, and that's why it is say part B is also essential, and this has to be there. So that's why it is not two separate certificates, but it is called part. So there is part A and part B, and in case of say civil litigation, see, because the BSA Bhartiya Sakshya Adhiniyam is applicable on civil as well as criminal cases. So this certificate is essential, and that has to be there so that there is no rejection. Otherwise, say the competent magistrate may hold that the evidence is inadmissible or irrelevant, or that it is not supported by a particular certificate, and therefore the evidence may be rejected, or it could be difficult to face the opponent because see, whenever some allegation is there, the opponent always alleges tempering हुआ है, doctoring हुआ है, fabrication हुआ है. So these types of allegations will be there, and it becomes very difficult to say justify that it is not tempered. Earlier procedure was they used to send it to the forensic science laboratory, that is the central or state forensic science laboratory, and even the investigative agencies like CBI could take the help of all the 40 laboratories under the CSIR, that is Council of Scientific and Industrial Research, and some other laboratories are there like say CCMB, Center for Cellular and Molecular Biology, Hyderabad. So many different experts are there. So earlier the procedure was like that, but now that there are mobile forensic and forensic experts, so for 7 years and more for criminal cases, this mobile forensic van will be there. For civil cases, commercially available services are there, and this has to be certified by the say certifying authorities. Just like say notarization, like you sign an affidavit and you get it notarized to prove that it is not tempered. Otherwise, if there is marriage agreement, sale deed, wasiyatnama, will, so these things can be tempered, and therefore the trusted third party. So that role is similar, and therefore this part B has been say made introduced in this certificate. So that way this will be there, and this third party will act as a proof. See, notary भी अपने पास एक copy रखता है. That means he is supposed to keep a copy in cases there is dispute. So the copy with the notary is considered valid rather than the copy with the parties, because the party can make tempering like they do in case of say wills or wasiyatnama. So such things can be say questions may arise in the court, and therefore this concept of part B certificate has been introduced to verify it by trusted source, trusted third party. There is also TPM, trusted party module, that is there in cybersecurity.
Thank you, sir. Very elaborate explanation. Just one more question to that. How does one recognize what kind of such services are available? Are they the list of them? Is there any empanelment mechanism, or can I simply just search it on Google? And how do I recognize that such and such agency or such and such service provider is the one to whom I will submit my data, who will give me the authentication by their mechanisms, and I will be able to obtain a part B also to be submitted to the court?
Yes, there are many rules under the IT rules. So first is the second schedule of the IT. It gives just the say this cryptographic mechanisms or security techniques, and there are certain rules. So there are lot of number of rules. You can download these rules from India Code website, and in indiacode.nic.in, many such rules and regulations are there, and these have been specified. That is, who are the certifying authorities, who are the foreign certifying authorities that are recognized in India, who are the say authorities that are recognized by the Reserve Bank of India to perform these digital transactions, or because we know that digital transactions are valid, but how they are valid, that we have seen under this IT Act today. So these are all valid, and these these have been certified. So you can find the information on internet. You can find from controller of certifying authorities. For financial transactions, you can get that list from RBI also. So these are available, and maybe you can refer to their websites.
So it's 5:45, so
I have another yes, 6 p.m. So
then later you can address it.
Yes, I have already sent you the copy of the presentation, and you can can send me the email for consent. I will consent for
Sure, sir. Sure. Okay,
uploading
sir.
this also. Thank you.
Okay, sir. Thank you so much, sir, for sharing your expertise on this topic today. Thank you, sir. And more to go in future. Thank you, sir.
Thank you so much. Thanks to all the participants also for listening and asking me questions. Thank you.
Okay, sir. Bye, sir.